A, on purpose, makes B believe that a particular plot of land belongs to him and thereby induces B to buy that plot of land. A was not the owner of the land at the time of sale, but after 1 month, A became the owner of the said land. A now intends to set aside this sale with B. Question is, can the sale between A and B be set aside? Why? In the above case, the sale between A and B involves a misrepresentation by A regarding the ownership of the land at the time of sale. Under Indian law, such a transaction can be challenged and potentially set aside on the grounds of fraud or misrepresentation only by the suffering party. According to the Indian Contract Act 1872, a contract is voidable at the option of the party whose consent was obtained by fraud or misrepresentation. Since A intentionally made B believe that he owned the land to induce B to purchase it, B has the right to void the contract upon discovering the truth. However, the fact that A became the owner of the land after the sale complicates the matter. If B chooses to ratify the contract upon learning of A's subsequent acquisition of the land, the sale may stand. But if B decides to rescind the contract, A may have to return the sale consideration and the sale could be set aside. The Supreme Court of India has held in various judgments that if a sale transaction is vitiated by fraud, it can be set aside. Additionally, the Specific Relief Act 1963 provides remedies for the rescission of contracts that involve misrepresentation or fraud. Therefore, whether the sale can be set aside depends on B's response to the revelation of A's initial lack of ownership and the legal action B decides to take. If B opts to rescind the contract, A's intention to set aside the sale may not be necessary as B's action would suffice to void the transaction. Conversely, if B ratifies the contract, A's attempt to set aside the sale may not succeed unless A can prove other grounds for the rescission under the law. Next question is, explain the doctrine applicable in such kind of situation. State relevant provisions. Here, A was not the owner of the land at the time of sale, but later became the owner. Is addressed by the doctrine of feeding the grant by estoppel, which is provided encapsulated in section 43 of the Transfer of Property Act 1882. This doctrine applies in Indian law and operates under the principle that if a person sells property pretending to be the owner and subsequently acquires interest in such property, the buyer's title to the property is validated. The relevant provisions from section 43 of the Transfer of Property Act is where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration. Such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. This means that if A, after the selling the land to B under false pretenses, later acquires the property, B can enforce the sale against A due to the doctrine of estoppel. A cannot deny the sale on the basis that he was not the owner at the time because his subsequent acquisition of the property validates the sale and he is stopped from going back on his representation. The doctrine ensures that a person cannot take advantage of his own wrong. It protects the buyer, B in this case, who was misled by the seller's false representation. Therefore, A's intention to set aside the sale with B would likely not succeed because of the doctrine of estoppel, as A's subsequent acquisition of the property fits into the grant made to B.